Welcome to Massey Dialogues. Massey College is a place for ideas. It's a place that has for mission to nourish learning and serve the public good. Massey College, the physical place of Massey, is located on Indigenous land, the cherished land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit. And we're very grateful for the ability that we have to continue to work here. The Massey Dialogues are based on the idea that to serve the public good, we have to build bridges between cultures, bridges between generations, and between disciplines. And that's a little bit what we're going to do today. We're going to talk about justice in the era of COVID-19 with our visitor at Massey College, the Right Honorable Beverley McLachlin, former Chief Justice of Canada. And I know we'll invite also a junior fellow who's going into third year at law school here. And then eventually my predecessor, the Honorable Hugh Segal, will join us as well. So it's an impressive panel today to discuss this very important issue. So let me introduce more fully our participants. The Right Honorable Beverley McLachlin served as Chief Justice from 2000 to December 2017. She now works as an arbitrator, a mediator, internationally recognized. She is the companion of the Order of Canada. That's the highest accolade that the Order of Canada provides. She has over 35 honorary degrees from universities in Canada and abroad. The Supreme Court has written 2,094 judgments in which she participated, and she wrote 442 of them in a wide range of subjects. And we've read, all of us, I'm sure that Avnee, our junior fellows, going in third year, has read a lot of these decisions. She also sits as the Justice of Singapore's International Commercial Court and the Hong Kong Final Court of Appeal. She's also an author. She has written a mystery novel, but also more recently her memoirs, Truth Be Told, which is a fabulous read and is still on top of the charts. So multiple talents, and so wonderful to have you here. Welcome to be here. And Avnee Paranjape is a third year junior fellow, and she's going into third years at U of T in the law school. She completed a BA honors in English and a Bachelor in Science and Biology at University of Regina before moving to Toronto to do an MA in English. She was one of 10 university graduates selected for the Parliamentary Internship Program in Ottawa, and she is the chair of the Massey group of law students, the Massey Quarterly Court. She writes for Ultravirus, the independent student newspaper at U of T Law School, and she's interested in criminal law, theater, Canada's parliament, politics, and scientific literacy. And she just started her work at the Crown's Law Office remotely from Regina to a Crown Law's office in Toronto. Welcome, Avnee. It's lovely to have you. And the Honorable Hugh Segal was the 5th principal of Massey College, political strategist, author, commentator, academic, a former senator. His entire life, his public policy focus for many years has been on reforming income security in Canada and proposing a basic income guarantee. He's also an expert in foreign policy. He was the chair of NATO Council of Canada, co-chair of Democracy 10 International Strategy Forum. He has honorary doctorates from University of Ottawa, from the Royal Military College, honorary captain of the Royal Canadian Navy, and Order of Canada, and a wonderful person to have on this panel because he and the Right Honorable Beverley McLachlin were together at Massey for a little while. So welcome all three of you. Merci beaucoup. Thank you very much for being here. So let me start with you, Madam McLachlin. You chose the title Justice in the area of COVID-19. So now that you're a mediator, you're an arbitrator, as your life changed a lot because of COVID?
Well, it has. I was very, very busy before COVID came, but I like to think of it as I do much less travel now, but I seem to have more meetings and in fact, my days are so full, I don't have enough hours. I wonder, how did I ever manage when I had to get from place to place and spend time in airports? But there have been, because the work I do with arbitration, we have been doing a lot of it on by audio visual mediums, and a lot of it, some of it's done by telephone, and you can work very well electronically. I'm at my cottage right now in Quebec, and so the work is still there. But what has happened really, a couple of things on personally, time to reflect a little bit on where you're spending all your energies, and it's been a quiet time in a lot of ways, and to some extent lonely, but more peaceful, and that's been good. The justice system aspect of it has been taking up a lot of my attention. I'm affiliated or sit with or work with a number of groups, some ad hoc, that have sprung up that are very, very concerned about the impact of COVID-19 on the justice system. We had a system that was often underfunded, certainly with respect to the courts, before COVID-19, was working right at the edge of its capacity, sometimes almost beyond it. And then suddenly we have this disaster. So we have backlogs, but now we have the bigger backlogs. People are asking, what is going to happen? How are we going to deliver justice in time? And beyond that, how can we deliver it better in the future, using what we've learned from this crisis?
Well, it's been quite an issue in terms of we had been wanting to have the justice system catch up to the 21st century and use technology a little bit more all through Canada. And now I think we see the importance, but we're not used to it. There's still some big gaps in access to justice in that way. And I think you've been a proponent of access to justice for most of your career, so I guess this has just re-emphasized it. Yeah.
And so I think it's a wake-up call. We all thought that we would fix things gradually. We'll make an improvement here and an improvement there, and things will gradually get better in the justice system. But now that the COVID-19 has punctured that myth. We can't do it that way. We will never get to the right place, the place we want, where Canadian women, men, and children can find justice affordably within a reasonable time. So we're going to have to reconceive and develop a new vision for justice, I believe. I am an ex-judge. I believe that the court system is constitutionally important. The idea of independent judges are very important. We have to build up and better support our court system with technology and other things. But we have to also have a lot of other help around it to help people in distress settle their disputes, be they family disputes, civil disputes, criminal matters. We've got to provide more support through ancillary institutions.
Well, we all know that the COVID crisis is shining a light to some of the ways in which our long-term care system will have to be reformed for sure. I think we see the vulnerabilities being increased, and I guess the justice system is another place where its vulnerabilities, its frailties are being highlighted.
Absolutely.
So when you talk about the expanding, you mean, informal dispute resolution supports for that? Do you see that there is an appetite for it as a result of COVID? Will people say, oh, well, I can't get a trial date for 3 years, so I might as well settle?
I think it might happen because that's already happening to some extent. But arbitration is capable of being done very fairly quickly. I've been doing things I would never have dreamed of doing, hearings involving 15, 20 lawyers, doing them online by audiovisual, Zoom or whatever, and it works. And we're realizing that as a judge or as an arbitrator, I'm listening to the lawyers make their points. They put up their PowerPoints. They slide in their evidence, provided they're prepared and have the technical backup and everything in order to go in at the right time. They make very effective presentations. And I've always been an advocate of oral hearings. Mm-hmm. I don't really like when I was a judge, I didn't like to decide things on paper very much, certainly not important things. So I think we will realize in the justice system that we can use these technologies much better than we have in the past. But there'll always be a place for, the in-person trial. And that's what we have to figure out. Where do we need our courtrooms and our traditional ways of doing things? What can we do better elsewhere? And how can we meet those needs that may not be readily met through the system as we work this out?
So let me hear from our young lawyer here, just starting in the Crown Law Office now. So how does it work? You're doing it remotely, but how are you managing?
Well, personally, I want to emphasize, first of all, that I am one of the lucky ones in terms of law students right now, and that I've kept my summer job and I was able to start on time, if remotely. For us, it's certainly not the summer we imagined having at the office, but my office has been very supportive in figuring out ways to deliver training remotely, ensuring that we're having a lot of contact with many counsel in the office frequently, so we can meet many people, even if we're not all working in the same space. So, we're adapting, and it's really wonderful to be in the middle of, as difficult as this process is, to watch an institution which is government. You don't necessarily expect it to be as nimble as it is having to be right now, and it's been really great to watch that transition and be part of it.
So are they things that you'd like to keep after COVID? Like, are they things that you see, well, this is a big improvement, we should continue to work this way?
Certainly, I think that the idea of sort of expediting meetings through video conferences and things like that, or sending more emails, so that kind of makes processes faster. At the moment, I'm still so new to the office. I only started last week that I don't know exactly what all the changes are going to be yet. But I'm looking forward to seeing how we evolve our work as the summer progresses.
Have you been able to see a hearing done online, a criminal hearing done online yet?
Not quite yet. I believe the Court of Appeal is still trying to figure out how that will work, but it is very interesting for someone who has really no litigation experience yet to perhaps be experiencing oral advocacy of a slightly different character when everyone is encountering or entering the courtroom through these technological vectors of telephones and video cameras. So I'm looking forward to potentially seeing that, but sadly out of my hands, whether or not I can see a virtual hearing.
So are there things that worry you about this crisis in terms of, your future, the future of as a legal professional?
Absolutely. I think there's we've already seen the effect on law students this year. I've gotten to keep my summer job, but we've seen that the summer jobs of many law students across the country have vanished or been shortened significantly just in the last few weeks. And these were jobs that students worked very hard to secure months ago. And for many, that summer position is a really important step in securing the articling job that we'll need as part of the licensing process. So there's a lot bound up in the loss of a summer job that goes just beyond this summer. There's a lot of uncertainty and anxiety for law students right now. The students of all types, really, but particularly law students who have taken on a great deal of debt in order to even attend law school in the first place. I think it'll also be interesting to see how the way that the legal profession is populated in terms of hiring will change as a result of this pandemic, because so many law schools across the country, I believe most, if not all, have adapted to a pass-fail or credit-no credit system. And that was a very important policy that students across the country advocated for in order to ensure that grading is fair. But graded evaluations are really fundamental to the hiring process, of course. So in a system where these timelines to employment are so short, it'll be interesting to see how in the next little while prospective employers, which are firms, government agencies, and even courts in terms of judicial clerkships, adapt to have to relinquish these graded evaluations and adapt to something that's fundamentally more holistic. And these might sound like very specific concerns for law students, but in fact, I think they actually have ripple effects on the entire legal profession, because these are stages that deal with entry into the profession. And when entry into the profession is affected, that really changes how the entire legal ecosystem will evolve in the future.
Well, that's interesting. So I knew that if there was something that the law students thought should be changed, it may have some impact in the long run. So are you? We know that we've talked on these dialogues often about the digital divide. That is, for some people, access to a computer is easy. For others, it's not possible, and there are lots of barriers that may come from moving online and therefore accentuating some access to justice problem that already existed. Is that something that you see is that something that the law students are concerned about, or in your group of discussion groups?
Well, I mean, I think for the most part, the law students in my cohort come from urban centers. So internet access is something that we're very fortunate to have, but I am concerned about university students and even younger students, elementary school students and high school students across the country who perhaps live in parts of the country where internet access is not as secure. And in terms of the question of access to justice, I think that while digital hearings are a wonderful and welcome development, we have to ensure that access to internet doesn't determine access to justice in terms of not having that type of secure connection, meaning that you don't get that type of hearing.
Well, let's hear it from Hugh Segal. Yes, go ahead, Madam McLachlin.
I was just going to make a comment on that. When you can't just paste technology onto an existing system and think it will do everything. For example, when you're using audiovisual means, people's iPhones, computers, and so on, and you say this is going to be our new courtroom, and you have to take into account that there may be privacy issues. There may be security issues. We're used to the idea of an open court where the press can report, but a person in a family may be wanting to give evidence about how she suffered abuse. And the person who is the abuser is in the same room or in the same house. It makes things, there's a lot to think through. And so we have to have smart technology. We have to use it in a smart way that preserves our fundamental values. Sorry to butt in.
No, that's okay. That's the point of these dialogues. So let's bring in Hugh here about this perspective on social equality and the way in which COVID has kind of shone a light on greater inequalities in our society. You've been talking about this for most of your career. Any comments on the access to justice part?
Well, there's an old line down on Bay Street where when the tide is high, everything looks good. But when the tide goes out, you realize who's not wearing any bathing trunks. And I think what the COVID proposition has done has exposed some of the intrinsic weaknesses in our social and community infrastructure. And I'm actually, generally speaking, pretty pleased with how well government has responded. Mm-hmm. It's not been perfect, but the federal government has moved very, very quickly in terms of income support for people who lost their jobs, and a measure of support for students, and a measure of support for other groups who are going through a particularly challenging time. And we've also seen a whole series of changes. Beverley McLachlin talked about hearings that are being done by Skype or by Zoom. A lot of legal documents can now be filed digitally. A lot of signatures can be witnessed in ways that would have involved personal presence and which can't now be executed now. And small things in everybody's life. The notion that you call your pharmacist to get a prescription renewed, and now they can renew it even though they can't find your doctor, because because the pharmacist has enough skill to know if there's any risk in renewing. So all these changes that have been brought into place, which often happens after a big crisis like a pandemic or, God forbid, a war or those sorts of things, the population is generally very supportive of these changes, and they are not going to want to see them evaporate when we get through the pandemic, or we find a way to manage it so we can get back to some measure of normal life. And so I think all the regulatory bodies, the law societies across Canada, I think the colleges of physicians and surgeons across the country, and at the national level, the pharmacists, all of them are going to have to look at what were the changes that were brought into place. Daniel Martin, one of our colleagues at Massey, who's a senior fellow and is the chief medical officer at Women's College, was saying the other day that in her view, she has seen more change in the way medicine is managed in a period of a few days than she thought she would have seen in a period of many years. The advent of virtual medicine, the advent of people working across disciplines very, very quickly to come up with rapid answers to difficult problems, whether it's about infectious disease or other circumstances. So I think it's very important that we don't let the inertia, which sometimes follows a crisis, roll back the tape, because I think our fellow Canadians will be justifiably very upset about that. And I think we all have a duty in a kind of lessons learned function to facilitate a discussion of what changes were good, what changes should be implemented on a more permanent basis. And we have to be honest about those things which clearly did not get managed well, like the long-term care circumstance, and how that economic model, frankly, has to change. And I think to the extent the leaders, provincially and federally, who are now quite popular because they're deemed to be doing a reasonably good job in difficult circumstances, if they abdicate from that larger agenda of change, I think they will find their popularity collapses pretty quickly. But if they pursue it in a collegial way and in a consensual way, but working with others and across disciplines and across parties, I think they will be able to achieve some significant measure of public support, and it may build aspects of a society which are stronger in the future than they were before the COVID virus hit.
Well, it's interesting to talk about the way the virtual medicine is happening. We've talked about that on the dialogues, but the legal system has not moved in the last 3 weeks in a very quick way. So are there things about the legal system that make it harder to move so quickly, or are we? Is it just because it's not an essential service? What's
I'm the only non-lawyer on this panel, so I should be very careful where I go with this. But I would say this. I would say that the legal system, because it's part of an institutional framework for law and order and the rule of law and due process, legitimately has some staged approaches which relate to the right of appeal and the right to be heard and the right to a defense and the prosecutorial freedom that governments have to have when they have evidence. And all of that is a process which by definition cannot be collapsed. The question is, can it be managed in a way where average people feel they have more access to the law than is now the case? And I think that, Beverley McLachlin has been a leader on this file. Others have taken similar positions, and I think there's a will now to move ahead. Whether the tradition and the institution of the law societies and the various judiciaries across the country are ready to embrace that remains to be seen. But I have no reason to believe that intrinsically they would be resistant if the evidence is clear and the process of change is fair-minded and provides for full understanding of exactly what's going on.
So, Madam McLachlin, this is the legal systems changing it, trying to get it to modernize has been a long-standing and a arduous task.
Well, I'd like to comment on that. In fact, first of all, there are changes happening. Several courts of appeal in this country are now hearing their appeals online with video. And there is no reason why this can't work and can't work well. It may not work so well for a trial where you have to have cross-examination and those kinds of things. But certainly for courts of appeal, this can be done by video. People can have their day in court. They can talk to the judges. And this is happening. Other courts, a lot of the provincial courts have found great new ways to use technology, even before COVID, to help them. For example, bail hearings, that you don't have to bring the prisoner in from prison. You simply have a room in the prison facility and the judge on the other end electronically, and everything is worked out. And everybody likes this better. No prisoner wants to sit in the back of a van all day and going to and from a court. And this has all been happening on crisis management of family issues and so on. So there's a lot of good news that the public doesn't know, and there have been a lot of changes. One of the big problems is, and I have to say this, money. Yeah. When the money gets divvied up around the cabinet table, health, education are the big, and the justice minister, who used to be traditionally one of the most powerful ministers at cabinet, now not so much, or the attorney general provincially, because it's the provinces responsible for the administration of justice, and they come away with very little. And this has got to change. And the only thing that can change it is the public realizing that the justice system is important. You can be the best chief justice in the country, in your province, and want to change everything, want to get new ways of scheduling cases, want to get electronic filing. We all know how to do it. You know you could operate so much more efficiently, but can you get the money to implement it? Can you get the $500,000 that you need? No. And so this is what's been holding us back. And I do believe also that we need what I'd call a business plan that doesn't lurch from election to election, because certainly provincially, not so much federally, but provincially, a new government comes into a province and they cut everything that's been built up before. Legal aid and other things. And then the system is scrambling just to try to survive, to treat those basic cases. We have to have continuity. So we need more money. We need a business plan that will take us beyond 3 or 4 years, that will give us continuity so we can build a better, more efficient, and more accessible justice system.
Well, this plea is going to come at a time where there will be lots of pressure for money. Because we suspect that there's going to be a big recession. So if you're a young person now coming into the legal profession, are you worried about that? Worried about the fact that maybe there won't be that much money for the justice system? We won't be able to recognize it as being a key service vis-a-vis the healthcare system that we now treasure. What does that mean? So why did you choose law then?
Well, I chose law initially because so I did my master's in English, and I really wanted to use those skills to have a career that had an impact in the greater world, the skills of being able to read critically and write carefully and be very analytical about things. I mean, I think I'm as concerned as any university student is in Canada right now, trying to find a job in the midst of an economic disruption unlike anything we've ever seen in our lifetimes. So that's certainly something that I'm concerned about. I know that, I have some limited experience working as a political staffer, and I know that the way that things tend to operate is that, it's always crisis management. There's always a crisis that has to come first, and it really may depend on the government recognizing that there's a crisis in the justice system, and it's not just a health crisis or an economic crisis that they need to occupy themselves with at the moment, but that there is a justice crisis that requires investment.
And we used to say that, the system on the rule of law requires a minimum of investment, otherwise it can't function in this way. So if you had to put the case to a cabinet table why they should invest more in the legal system, what would you say?
I would say that our entire society operates on the principle of voluntary compliance. Mm-hmm. Yes, we have laws, and yes, we have police forces to enforce the laws, but thankfully we're not a police state, and we don't have enough police officers to enforce every law and every bylaw. And the reason our society works is because people believe that being compliant with the law, observing a red light, even if there's no traffic coming, actually makes a lot of good sense. It's in the public interest. It's in their own interest. And the reason that people come to that conclusion, and this is very important in terms of the independence of our judiciary, is that they see the operation of the system operate essentially fairly. Not always quickly, not always with as much speed as some would like, but intrinsically it is an avatar for a society that is based on fairness, decency, the rule of law, and everybody's right to be respected in the process. So when the law administration of justice comes into disrepute because it's underfunded, because it can't cope, because the delays are too long for someone coming to court to make their case either in a civil or in a criminal procedure, that will absolutely begin to affect everybody's sense of fairness. And that has serious threats for everything. It has serious threats for the business community, serious threats for the coherence of our political system, serious threats for the balance of freedoms and responsibilities which constitute the way we live our life. And I would make the case to any cabinet that the best investment they can make is in the administration of justice in a way that sends a message that all the other attributes and all the other pillars of hope and stability and opportunity in our society are valid and are operating according to the law. Because if we lose that, then you're faced with either a totalitarian option at one end or a more anarchic option at the other, none of which will produce the quality of life Canadians want for themselves, their families, their communities. That's where I'd go if I was given the opportunity.
That's good. Well, I actually, it's so well said. But so in a way, you're linking, peace, order, and good government, but also equality before the law, which is.
Natalie, when I was in the Senate, I would often make speeches, and I would talk about peace, order, and good government, and then I'd say, 2 out of 3 on any day is not a bad average, all things considered.
I remember this one. There's also equality before the law, I think, which is another tenet that we want to observe, because otherwise it makes it's impossible to continue to support a system that would not treat everyone the same way. Does that concern you, Avnee, about when you move forward, about whether that's a real challenge for your generation to remedy this, to look after this, to recognize the inequalities?
Absolutely. I mean, I think that there's a lot of inequalities that we have to keep an eye on as this crisis unfolds over the next few months in the legal profession. I think access to justice in terms of access to a courtroom is important, but it's also a matter of access to the profession. My concern is that economic depression will exclude more prospective students from the legal profession. I mean, already prohibitively high tuition has already limited who has access to law school, and that might just be exacerbated. And so I'm worried that access to the bar will become exclusively, and not just predominantly as it is now, available to those of particular socioeconomic backgrounds and with particular life experiences. And that's a significant problem in terms of diversity of the bar. And a more diverse bar is better able to represent and serve a diverse public. There's value to nurturing diversity in the legal profession and a real loss when that diversity is neglected. And I think there's really no more important time to think about that than right now when diversity is at risk. So that's one aspect of kind of the inequalities that I think we have to keep an eye out for. Related to that, I'd also suggest that a further concern is how working from home will affect women in the law, particularly as long as childcare remains unavailable. We already know that on average, women tend to take on more of the caring responsibilities in households, and that includes professional women and women who are breadwinners. And in academia now, we have some data that suggests that women's research output has substantially declined in terms of solo authored articles since the onset of the pandemic. So it will be really important to keep an eye on how women in the law are being affected by the unique pressures of these circumstances, particularly in a profession where so much of our value is very closely tied to our productivity in very tangible ways in terms of billable hours and things like that. So I think that's some inequalities we're going to have to keep an eye on.
Yeah, very interesting.
One interesting question, Natalie. I notice, and I give the provincial government great credit in Ontario, they have provided emergency daycare for first responders, for police officers, for people who are working in essential industries. And so I'm really interested to hear the argument for why there should not be daycare for these very same people when the crisis has passed. I can't imagine what that argument would be. We needed them before. Now we don't need them. We're not prepared to give them the freedom to participate in society and to make their contribution. So, you know, I think that's one of those areas where changes that were brought in for good reason and to the credit of the governments involved during the crisis are not going to be able to fade away that easily without people wanting to understand why. Why are we letting this fade away now when we know that childcare is an absolute multiplier of economic contribution for society as a whole, and now that we're seeing it in a crisis, surely to God we can learn from that relative to how we proceed going forward.
Well, that's a good point. But today in the Globe, I think you saw that it did show that women were taking on a greater role in the childcare than the men. Their work hours had dropped significantly compared to their partners, their male partners. So we're not at the end of this. The issue of women in the law continues to be a really important one. I'd like to hear Madam McLachlin on this, who's been a champion, our first female Chief Justice, so a pioneer all the way.
Well, it's been a long road, even since I first started walking it in the late 60s and the early 70s. And we've come a long way. I mean, things are so much better for women now. But there are certain persistent problems that we just don't seem to be able to deal with. We make a lot of progress. We have a lot more women practicing law. We have much better conditions. They get paid equally. There's lots of good role models. Women are doing the job and they're valued for it. But we have difficulty with maintaining young women in the profession, because I suspect of what Avnee was just saying, the child care responsibility default always, not always, but often goes to the woman in a family. And we don't build ways for these women after the 9 or 10 or 15 years, if they do choose to take a diminished role in the law during that time when their children are growing up. We don't have ways to get them back in the system and functioning. We need on-ramps so they come back in and they'll never make it up, statistics show, with their colleagues. So we have to deal with these problems. We also have persistent problems of too few women partners in law firms and too few women in leading legal roles compared to men. So it seems sometimes to people who look at this that our progress is stalled. We've made progress, but it's stalled. And so that's where we need to put our efforts and our thoughts and our energy, I think, in why have we stalled in certain areas? What's going wrong here? And I love what Hugh says about daycare. I've been an advocate for so long of publicly affordable daycare. I saw a woman on TV the other night, and she was saying, I've been working at home, as many others have, but I've had my children at home too, and now the daycare is going to open, and I'll really be able to work at home. I mean, the idea, and I felt her. We do need to provide childcare. We built our workplace on an Edwardian model where mom was home all the time to look after everything to do with the family. And papa could go out and work great long hours and so on. We know families don't function that way now. Yeah. Both parents are usually working, but we haven't changed the model. And nobody's there for the kids, so the mothers usually have to pick up the slack. And so we need to get better daycare. Other countries have done it, and we can do it. And I believe that fundamentally the studies show, as Hugh said, that child care is an absolute multiplier of economic success. So you get that message across, I think maybe we have some hope. But I loved your argument, Hugh, where you said, how are having accorded daycare to essential workers, how are you going to justify it, taking it away?
Well, yesterday in one of our discussion on Massey dialogues, we were talking about the fact that after the Second World War, many of the advances that had been given to women disappeared because it was no longer needed. So there's an element, and I think we're all sharing this, about, are we learning enough from this crisis? Are we using the opportunity to actually change and sustain change over time? And I know that there's some questions coming from the audience here. So I have a questions from Joey Coleman. Do you expect COVID realities will result in the Supreme Court of Canada or the Ontario Court of Appeal changing plans to conduct sittings in places other than their home courthouses? If so, more travel, less, more video link, oral arguments? What do you think? I think you've talked a little bit about that, Madam McLachlin.
Yes, I think that the courts, I'm sure the Supreme Court of Canada, I haven't checked lately, but I think they're envisioned, they have video hearings going on. And so we will see that in courts of appeal. The Supreme Court of Canada also did travel to Winnipeg for some hearings last year. Probably a kind of a Supreme Court of Canada that could go to every little town to talk to every person is not going to happen. It would be lovely, but it just can't be done. But I think by using technology, we can make our courts more accessible and ready to take on. We have to keep doing justice. We can't let it stop just because suddenly we can't get together and in a room. And so justice is a fundamental, I think it is a fundamental service that
it's an
every
essential
government
service.
has.
Yeah.
It's an essential service.
Yeah.
So we have to find ways to keep justice going and to do justice. And I'm sure that we will. And this will be good for us because we'll have to force us into ways of thinking in new ways. How can we do this better?
So another question from Tim O'Leary. If the incorporation of technology in the justice system continues at the pace presently seen in COVID-19. Do you think there is an accompanying risk of loss of public scrutiny? I think the element that you're talking about courts rooms are supposed to be open to the public. People can come in and sit there and watch it done. If it's online, how are we going to capture that public scrutiny? Let's start with you, Madam.
I'll just go quickly. But if you're doing it by Skype or video or some sort of video system, you can obviously loop the press in. So that's not a problem. It's harder if you're doing a child application with a person in their home. They may not want the press there. There are security and privacy issues. But I was talking to the Chief Judge of the Provincial Court of British Columbia just 2 days ago, and she says, we're grappling with those problems. If we think it's a case where the press might be interested, we find ways to try to loop them in. So it's a work in progress.
Well, it's interesting to see in some Zoom meetings, you can imagine and put a different background so they don't see where you live, which might be something that we want to protect so that people don't see how you're living. Do you have any comments on these two questions, Avnee?
I think an interesting consideration when it comes to privacy and public scrutiny in courtrooms is that courtrooms have, in the space of a courtroom, has a physical limit on the number of people who can observe the proceedings. And how do you place limits on that if a court proceeding is going to be broadcast online, especially if it's a very sensitive matter? So that's something that I've been thinking about a little bit as I've been thinking about how oral hearings might proceed in this era.
What about you, Hugh?
Natalie, if I were a working journalist, which I'm not, I would ask the following question. The Massey dialogues, which have been running for some weeks now, and they've all been taped and they're all available on the website of Massey College. There will be reasons why you can't do that for all court hearings, and I respect that. But if I were a journalist, I would say, if there are no reasons why a court hearing could not be taped and available on the website of that particular jurisdiction, that would allow journalists and others to go back and look at the hearing a week later, 2 weeks later, and do whatever they want to do in terms of analysis or point of view. I think we're going to be into the area where there may be some kinds of access for the media, except when they have to be excluded for good and substantial reason around privacy or the protection of the Crown imperative, etc., where they're going to have more access, depending on how that issue of keeping the digital and the visual record online for a period of time is handled. And that'll be, if I were a court reporter who had been, in many courtrooms and excluded on occasion when necessary, I'd be asking that very question. And that's something which the Judicial Council and others are going to have to think about.
Yes, any comments on this? Indeed, not only are we putting them on the website, but they're available on YouTube as well. So, and it's interesting that technology does reduce distances, but it changes time access and in a different way. So we're coming to the end of our hour soon. So I just wanted to have, what are your messages to the legal community? If I start with you, Madam McLachlin, these days, and I want to finish a little bit about talk about the Massey College for a few minutes. So let's do a round on the message to the legal community. So.
Well, I would say take advantage of the COVID-19 crisis and the window it's showing us on our justice system, and not only deal with how we do justice in this difficult period, but take on the task of making our justice system better when all this is over, more resilient, more able to give people access to justice.
Avnee, any concluding thoughts?
Yeah, I mean, there's no doubt that this this pandemic is extremely tragic. It's an extremely challenging situation for the entire world. But I think there is the potential for significant and long-needed changes, which to be implemented, which ultimately facilitate access to justice in the long term and well beyond this crisis. As long as we remain vigilant about the potential deleterious effects and how those effects might be exacerbated, we can use this moment in time as an opportunity to create a justice system or make the justice system work better for everyone. And I think that's something to be optimistic about.
Hugh, are you an optimist as well?
Well, I am. Most of the lawyers that I've had the privilege of meeting in my lifetime are pretty engaged, intellectually acute, and keen about achieving either a measure of justice for their clients or fairness in business agreements, as the case may be. And I think those skill sets, when applied to the issue of what changes are necessary, are precisely the right skill sets. So it's important to let those views be advanced and for the structure of the system to encourage that expression. That's the way we're going to make progress. If anybody tries to shut it down, we would find ourselves, I think, in unnecessary difficulty.
Yes, so I think we all recognize how important I think justice is to maintaining a democratic society, and we need this. Unfairness is not tolerable in the long run. And today is a particularly important day to have the Right Honorable Beverley McLachlin here, because she has been the visitor at Massey College for the last 6 years, and her term is ending at the end of June. So I'm taking this opportunity to thank her publicly for a great service and for the great honor that she gave Massey to become its visitor. And so I just wanted to say merci, thank you, miigwech. It was wonderful, and I'd like Hugh, who selected you, to continue and say a few words about your great service that you give to him.
I will only tell one story, but it's the one that I think is most indicative of how committed Madam Justice McLachlin was to the college. The first thing that she wanted to do when she was appointed as visitor, sworn in as visitor, was to go up to the lunchroom and have lunch in the dining room with other students. And when she went to the dining room, she always sat with the Junior Fellows. And she attended the Massey QC luncheons on a regular basis. And she was happiest, not in the formal events, which we all have on occasion at Massey, but really with the students, listening, chatting back and forth. They benefited immensely from her presence. They're inspired by her candor and her frankness. And it made Massey College not only a great place for law students, but for all the other disciplines who benefited from her perspective, her decency, her humanity, and above all, her kindness.
Oh my. It's been a great honor. Thank you so much for those kind words.
So, and maybe a word from the students who benefited from the visit of Madam Justice McLachlin, and also she came to talk about her book at a lunch with the Junior Fellows last year. So, maybe a couple words from you.
Well, I don't know if I could put it any more eloquently than Hugh just did, but it's really been, I think I speak for really all Junior Fellows and not just the Junior Fellows in law, that it's been such a privilege to have you as part of our community. And I'm sure that you'll come and visit, remain part of this community in some way. It's really always such a special opportunity to have you be here and to talk with you one-on-one. We just can't thank you enough. So thank you.
Well, thank you. And I'll be back often.
Yes, well, you know that Madam Justice McLachlin is now a visitor emerita, so therefore she has rank and standing anytime she comes back.
That's true. And I don't want to end this without recommending to read Beverley McLachlin's Truth Be Told. It's a lovely book to read, learning a lot, but also about Alberta, about so many great places in Canada, a fabulous career, a role model for all Canadians. Alors, merci beaucoup. Thank you very much, all of you. So I just want to say Massey Dialogues will continue next week. We're going to have on Tuesday the Right Honorable Adrienne Clarkson. who will be speaking about seniors care. So please come and join us next Tuesday.